Rick Durfee and Michael Koberlein of Durfee Law Group. And our webinar today is on family bank and family office training. And we're excited to have you with us. We're looking forward to the next little bit here to talk about these two very important and very powerful business and estate planning structures. And we welcome and encourage you to comment in with your questions as we go through this. And we're going to talk about these two structures from a variety of perspectives, not only from an estate and legal planning perspective, but also how other professionals might need to be addressing these or dealing with them in their own practices, both financial services and real estate services and other service providers. So the family bank, we're going to start there, and then we'll move on to the family office and talk about how these two integrate. The family bank, that's what we call it. It's actually a very old and very powerful tool that has been around for a long time. Let's come back to here. Okay. Very powerful tool that's been around for a long time. And it's an evolution of what used to be called a family limited partnership. And we'll talk about limited partnerships in general, but the family limited partnership was a structure where family members would come together, would pool resources, would form this partnership. And there were a whole number of benefits that would derive from that structure. They would be able to have cross-generation business ownership, consolidation of assets so they could have greater buying power or purchasing power, and also some powerful asset protection benefits. They could protect assets from hostile parties, and then some estate planning benefits, in particular a mechanism for sharing ownership across generations and selling or transferring or gifting assets at discounts. So we're going to kind of talk about all those. Today, that's evolved significantly, and we're going to go through how that's evolved and why today the structures are a little different. But I want to begin by talking about who needs this family bank structure and why. And I'm going to resume my share here so that you can see the diagram. You don't need to look at me. It's more interesting to see the diagram. Hopefully you can see. And that family bank on this diagram, you'll see represented on the right-hand side of your screen, this business limited partnership, and it's flagged family bank. This is typically used in several scenarios. One is ultra-high net worth people, where we're trying to manage lots of business entities and investments, and we need a single entity to do that under. It's also used for situations where we have just multi-generational business deals. So parents and children or parents and children and grandchildren are all doing deals together. The family limited partnership or the family bank makes a lot of sense. When we're doing some kind of asset protection, it makes a lot of sense. Or I guess another one is where there's just a complicated or complex business structure. This becomes important. And particularly for real estate professionals and financial service professionals, it's important for you to understand how this works because your clients are going to have these. You're going to come up against deals where you're trying to buy or sell real estate and it's owned by a structure, and you're going to need to understand how it's owned and why it's owned that way and who the players are. And if you're on the financial service side, your clients are going to have these structures. You're going to need to know how to structure their bank accounts. And let me add that, by the way, recent changes in banking laws have made the use of these entities candidly a little more complicated and difficult because of some know your customer regulations that govern banks. It used to be that if the entity existed and we could prove its existence at the state level, that opening up a bank account was simple and easy. Today, that's a little more complicated and we have to show the entire chain of ownership. But having said that, this family bank structure is, again, important for high net worth people, asset protection, complicated business structures, and multi-generational business structures. So some of you, especially people that are involved in financial services, may have heard of a family bank strategy. And the family bank structure is not the same as a family bank strategy. The family bank strategy is the use of life insurance to put large amounts of cash in and grow the cash tax-free, and then it can be borrowed out. And of course, it provides a death benefit. And that can actually be a very powerful way of creating cross-generational wealth. This is not that. We call it a family bank because of how it functions, what it does, and it involves more than just life insurance, although it may own life insurance. And I want to talk now about how this is structured and why it's a limited partnership or an LLC. And actually, limited partnerships have a very interesting story that's highly connected with American history and politics. It used to be that under traditional common law, which evolved in Britain, that when a partnership formed, the default position is that a partnership is a general partnership. And when a partnership is a general partnership, all the partners have general liability, which means anything blows up or causes a liability in the partnership, all the partners have to pay. Well, there was a situation where there was a general partnership. All these partners put in a bunch of money, and they invested in a shipment of goods that were sent on a boat to one of the colonies. And in that colonies, there was some political unrest, and the local colonists dressed up as Aboriginals. I'm trying to think of the politically correct word. They dressed up as native peoples, and they stormed the ship and they threw the tea overboard and resulted in what we now know as the Boston Tea Party. Well, the loss of that shipment resulted in general liability for all the partners, and they all lost their money, and they all were personally liable. They had to kick in more money to pay for the lost tea that was floating in the Boston Harbor. So under the British law, they evolved a new kind of partnership called a limited partnership, where each partner could contribute capital, but their risk was limited to the loss of their capital. They did not have general liability or the loss of other risks that became associated with the partnership. So today, the modern limited partnership is a derivative, an evolutionary outcome of that event that started with the Boston Tea Party. And there's two kinds of partners. There's a limited partner and a general partner. And you'll see on the diagram that limited partners with the LP there. Oops, I just moved that around. I didn't want to do that. And the general partner is the GP there. The general partner still has general liability, but the general partner also has control. The limited partner has limited liability. Their liability is limited to their contribution of capital, but they don't have control. So this becomes a mechanism for doing what you've all heard of, controlling but not owning. And the famous statement by some rich person, I can't remember who anymore, the goal of effective legal planning is to control everything and own nothing. Because that general partner has general liability, we're going to talk about that family office after we're done talking about the family bank here. But this makes it possible to have fractured ownership. Now, historically, when what we now call a family bank was a family limited partnership, all those limited partners would be people. They would be grandma and grandpa, and then all their children, and then all the grandchildren. And you'd have all these partners with fractional ownership. And here's why that idea failed and has been abandoned by people that actually think through the consequences of the planning. And here's another story. Out here in the East Valley, there was a family that back in the 40s and 50s put huge sections of real estate in a family limited partnership and commenced gifting interest in the family limited partnership to family members, which is one of the reasons why you use this. So you can give away a limited partnership interest, and the family members now own that limited partnership interest, but they have no control and they have no liability. They have an exposure. And in fact, the tax consequences flow through limited partnerships too. But here's what happened with this big family. It was a large family. They had lots of children, lots of grandchildren, and they started gifting this limited partnership interest when their children were young. In fact, before they even had all their children. So fast forward now 40 years later, 4 decades of making gifts of this limited partnership interest to the family members, and the oldest children and the oldest grandchildren had very large percentages of this limited partnership, but the youngest children and the youngest grandchildren had relatively small parts of the limited partnership. So a series of transactions came up where the family was selling off huge parcels of real estate in East Valley, which are now underneath houses and shopping centers. And as a consequence of these transactions, the older children were all going to get millions and millions of dollars. And the younger children and some of the younger grandchildren were going to get a whopping $10,000. So family members on otherwise equal footing, the difference in how much benefit they would ultimately enjoy from that family limited partnership varied by millions of dollars, which created terrible inequities in the family and family conflict. And there was a family fight and litigation, and awful things happened as a result of that. So today, no planner who knows what they're doing would ever cause natural persons to be the owners of either a limited partnership or an LLC. And some other things, if you think about it, natural people have some issues. Natural people die, they become incapacitated, they get married and have marital problems, they get sued, they can file bankruptcy, and on and on and on. And all of those issues with a natural person can cause problems for the company. So today, planners that know what they're doing will cause those limited partnership interests in the family bank to be owned by either a trust or a series of trusts, or by other business entities that are in turn owned by a trust. So we never have a natural person owning an interest in this, and we never have all the problems that are associated with natural person. This family bank, we show it here as a limited partnership. It can also be an LLC. And by the way, all those L's, the L in limited partnership, and you can have multiple L's. You can have limited partnership, or a limited liability partnership, or a limited liability limited partnership. Every time you add an L, by the way, the cost and the administrative overhead goes up, but you theoretically get more limits on your risk exposure with more L's. There's also the LLC, which is a limited liability company. And here's a material difference that as you encounter these, you got to know the difference, and you need to know the terminology. Otherwise, you sound silly and you'll mislead your clients and cause misunderstanding. In a limited partnership, the owners are called partners. A general partner controls, limited partner doesn't control. In an LLC, a limited liability company, the owners are called members. So members, that's it. That's what you call an owner. And the limited liability company, the LLC, is controlled by managers. And an LLC can be member managed, so the members are the managers and they're one and the same, or it can be manager managed, so that the members are the members and a third party entity is the manager. And with a family bank, if we're going to use an LLC in this capacity, almost always, in fact, I cannot think of an exception where we've ever done this. We will have it be manager managed, and we want that manager to be a third party, which is why we have the family office that we're going to talk about when we're done talking about the family bank here. So I want to put this in perspective so that you get the whole picture, because there's some nuances that challenge people. Partnerships, limited partnerships, the owners are called partners. Limited liability companies, the owners are called members. Now, if you have a corporation, what are the owners called? Shareholders or stockholders. And in a corporation, what are the people who control it are called? Well, they're called a board of directors or directors, and they're called officers, presidents and vice presidents. So LLCs don't have shareholders, they don't have directors, they don't have officers, they have members and managers. Limited partnerships also don't have any of those things. They only have limited partners or general partners. Now here's the confusing thing. LLCs in particular can elect how they're taxed. So an LLC can be taxed as a partnership. It can be taxed as a C Corp. It can be taxed as an S Corp. It can be taxed as a disregarded entity. It can be taxed even as a nonprofit in some situations. So even though we have an LLC where the owners are called members, it can be taxed as a partnership. So yeah, they're members, but for tax purposes, we're going to call them partners. Or it can be taxed as an S corporation. So even though they're members in an LLC, they're treated as if they own an S corporation. And this causes enormous confusion in people who have these things. We'll have somebody coming in that they'll say, oh yeah, I have an S corporation. And we look at, no, you don't have an S corporation. You have an LLC taxed as an S corporation. Or they'll say, I have an LLC and I'm taxed as a partnership. And then we'll look and say, yes, you have an LLC. No, you're not taxed as a partnership. You're taxed as an S corporation. So the legal status, are you a member or a partner or a shareholder? And the tax status, are you taxed as a partner or is it disregarded and you're just taxed as a natural person, are two different things. And it's important to distinguish those. And for other professionals dealing with these entities, as you encounter them out there, it's important to know the difference. By the way, with this family bank structure, universally, with no exception that I'm aware of, we want it to be taxed as a partnership, never an S Corp, never a C Corp, never disregarded. We want it taxed as a partnership. And there's some complicated reasons for that, but the simple reason is this. With a partnership, the partners, or if it's an LLC, the members may contribute property and they may withdraw property. And that event of putting in property or taking out property is not in and of itself taxable. What's taxable is when there's an income or a loss on the property that's owned by that entity, by the family bank. So that gives us greater flexibility in planning. Also, when it's taxed as a partnership, we can have greater variety in who the owners are. The owners can be a variety of different kinds of trusts, even charitable trusts for that matter, and without triggering an adverse consequence, which might happen if it's, for example, taxed as an S Corp. So, and by the way, let me comment on this with LLCs. You're going to encounter LLCs out there that are going to own real estate, they're going to own brokerage accounts, and very often, especially if the LLC is set up by a CPA, the most common form that we encounter is a single member LLC, which is treated as a disregarded entity for tax purposes. So the owner will be the 100% owner, one member, and the entity, the LLC, will be disregarded for tax purposes, which means that all of the tax consequences, all the gains and losses of any kind, flow to that single member and are picked up on a schedule on that member's personal tax return. And CPAs favor this for a couple of reasons. One is it's very simple for tax reporting. and which makes sense. Okay, it's easy for tax reporting, and it's easy to set up. It doesn't require anything fancy. However, when we want to actually protect something, the single member disregarded entity is, for the most part, almost completely ineffective. So if somebody's thinking, oh, I have a rental property, I want my rental property to be protected from me, and I want me to be protected from my rental property, so I'm going to put it in an LLC. If that LLC is a single member LLC that is disregarded for tax purposes, just saying it is not protected. People think it's protected. They're told it's protected. Their CPA probably thinks it's protected, but it's not protected. Those single member LLCs get clobbered every day in the civil courts and in the bankruptcy courts. And the rationale is pretty simple. Hey, there's only one member here, and they're the manager, and it's disregarded for tax purposes. Your Honor, they say to the judge, please let us have the stuff inside that LLC. And the judge says, yeah, I can't see any reason why not. And so the LLC gets penetrated, and that rental property that we were trying to protect gets gobbled up in whatever the liability is. So this is one of the reasons why with the family bank or with any entity that we want to actually protect from liability, if we're trying to do risk management and have asset protection, we want that entity to have more than one owner. So more than one member, if it's an LLC, and if it's a limited partnership, more than one partner. And let me talk about, well, why does that matter, and how does that specifically play into the risk management or the asset protection feature? If Michael here, my co-counsel on the call with me here is Michael Koberlein, counsel in our law firm and a great attorney. If Michael and I are partners, and one of you, in fact, we'll pick on Mara. Mara sues me and gets a judgment against me. And if Michael and I have a limited partnership or an LLC together, and we each own some fractional share, and Mara gets a judgment against me, and Mara wants to take away my ownership interest in that entity, what does that make Mara with Michael? Well, it makes her a partner. Now, Michael, who had no deal with Mara, who doesn't even know Mara, can say, I don't want to be Mara's partner, and you can't make me. And Michael's correct. He cannot be compelled to be a partner with someone he does not want to be a partner. So that other owner gives us the power to exclude hostile owners that we don't want in the partnership. So that's a very powerful tool for asset protection.
So Rick, I have a question with respect to that. So we have a lot of people who, well, at least I've had some come up to me recently and say, hey, I have a business. It's not a huge business. It's just a small one. So I've got a single member entity, and I've got it set up to where I just set up the LLC, essentially the way that you said it, single member, disregarded entity. Is there a threshold between just being satisfied with having an LLC set up that way, as opposed to implementing the structure you're talking about with the more than one member and manager managed entity?
Yeah, that's a great question. And yes, there is. So sometimes, in fact, let me talk about the exceptions to the rule I just said. When would we just go ahead and set up a single member entity? We typically do that with a small shop, the barber shop, the beauty salon, the printing office, sometimes even a real estate professional company it's one person or a married couple. It's simple, it's easy. We're not concerned about asset protection. That's not our goal here. We just want to have a discrete entity, a brand that we want to do business in. We want to have a separate account for accounting purposes, but we're not concerned about protecting that entity from our personal liability. And let me talk about, in fact, this kind of relates to containing risk and excluding risk. And because the single member entity does contain risk, but it does not exclude risk. So let me kind of expand to this a little bit. And the metaphor I like is a good fence keeps your dog in and it keeps the neighbor's dog out. So keeping your dog in is the equivalent of containing risk. So if there's a risk event inside the company, we keep that dog in, we don't let it out. And single member LLCs, by the way, do that. They do that just fine. They contain risk. Excluding risk is if there's a bad dog outside of our yard and we want to keep that bad dog out. We don't want the bad dog to get in our yard where it'll bite our kids. So single member LLCs do not exclude risk. So here's the example. We have our barbershop and Sam's barbershop, and we set it up as an LLC. And maybe we even elected to have it taxed as an S Corp because we get a few tax benefits that way. That Sam's barbershop LLC would contain risk. So if a customer on a rainy day slips and falls in the entryway and there's a slip and fall lawsuit, Sam personally would be protected from the liability of that slip and fall. But it does not exclude risk. So if Sam has a car accident on that rainy day and hits a busload of brain surgeons and kills them all the families sue for income replacement and there's judgments in excess of his assets, they're going to go take the barbershop. They're going to go take the equipment and whatever equity and cash he's got in the barbershop. So his barbershop is not protected from that outside liability. So the single member LLC contains risk. It keeps the dog in, but it does not exclude risk. The outside dog, the bad dog on the outside, it can get in and it can hurt you. So thinking about rental properties, because that's another thing that comes up. People will throw a rental property in an LLC. And if it's a single member LLC, okay, if we're trying to protect outside things from liabilities associated with that rental property, the single member LLC works. We can do that. But if we're trying to protect that rental property from things on the outside, the single member LLC doesn't work. You got to have more than one member if we're trying to protect. So often, and in fact, we see this a lot with rental properties. Someone has a string of rental properties and they're all highly leveraged. They have a small amount of equity, but not a big amount. So sometimes they'll put those in a string of single member LLCs because we just want to contain the risk. But we're not worried about excluding risk. If the outside liability gets in, there's not that much equity. We're not worried about it, but we want to have any risk associated with that property contained so it doesn't get over and hurt things. Also with rental properties, do I have to have a separate LLC for every rental property, or can I throw a bunch of them in the same one? And that comes down to balancing risk aversion versus complexity aversion. The more we protect against risk, the more complicated it gets. So if the individual says, well, yeah, I'm concerned about risk, but the complexity makes my head hurt, I just can't stand it, then okay, maybe we have an LLC and we put multiple properties in there. But often that's going to be, again, highly leveraged properties. If there's several that I've got big mortgages on them and there's not that much equity, but there's one that's free and clear, okay, maybe we peel off the one that's free and clear. We put it in a separate LLC. Maybe we even put it in a multi-member LLC, and we put the low equity, highly leveraged properties together. And that's a discussion that the client has to have. And there's so many factors. Again, their risk tolerance, their complexity tolerance, their willingness to do separate tax returns. That's another issue. With the multi-member entity, there's the setup cost. You pay the lawyer to set that thing up. There's the operational cost. You have to do a tax return on those multi-member LLCs every year. And then there's the complexity cost. Dang, this is complicated. It makes my eyes water. I can't think about it. So you have to balance those costs against the benefit. Okay, we have the risk management. We've contained the risk or excluded the risk.
I would like to interject something here, Rick, quickly, and that is that despite the fact that some of these things in a multi-member LLC can be complicated, once our clients have been exposed to this kind of structure, and as they kind of go through the process and they get the gist of how it runs and how it works, they get it. It takes some time, but eventually they get it. They can do it. It's not something that's impossible. There is that balance between the risk and the complexity that you talked about. And once they decide where they want to be at on the spectrum, they can look at this system and recognize, okay, this is how it runs. I get it. Let's move forward. And the main complexity with these, at least as I understand it, is that the initial part of this with individuals who have never been exposed to it or who have, but their exposure is limited. And so it's at the end of the day, it's if you want more protection and you're okay with the complexity initially, it's a good system.
Yes. And I've also seen people evolve. They'll start out and they'll say, okay, this is overwhelming. Let's just do single memberships. And 3 years later, they'll go, okay, I get this now. I've been working with it. And my buddy over here got sued. I don't want what happened to him to happen to me. And so sometimes we'll start simple and then add complexity as they get a comfort level. And it's really interesting. In fact, yesterday I met with a new client who, as we went through his structure, it's incredibly complicated. He's got multiple entities owned by different people and different structures. And he kept telling me how simple it was and how he wants to keep it simple for his children. And he was describing, I think he had 9 checkbooks. He says, but I only want my children to have 1 checkbook because I want to keep it simple. But it's simple for me. And the complicated thing for him was understanding to go from 9 checkbooks to 1 checkbook required peeling off a bunch of structures and reducing the number of structures to fewer structures. And he didn't want that. So he wanted, so that's a conversation. Sometimes people want to have their cake and eat it too. I want simplicity, but I want 9 checkbooks. Or I want protection and I only want 1 checkbook. Well, there's some trade-offs. An important thing to recognize here with all of these things, in fact, this is something that gets left out a lot. People will set up these structures with multiple members and the members will be there and the entity will be what we call a naked entity, a naked LLC, or even a naked limited partnership where, yes, there's more than 1 member, but there's no underlying support documents. And in particular, with an LLC, the document we're looking for is an operating agreement and then related evidence of ownership, membership agreements, and so forth. And the reason why that's critical is the rights of the parties are going to be governed by their contract, which is the operating agreement. So if we want, for example, to exclude hostile predatory takeovers by plaintiffs who sue one of the members, we need to have operating agreements in place that create rules and procedures by which new members are admitted so that we can allow in the members that we want and we can exclude the members that we don't want. So if we want to let in a trust or a charitable member because they're a friendly party and they're going to be helpful to the family and to the family business, great. There's a process for that. But if we want to exclude the plaintiff that sued someone or the ex-spouse, that's a classic one. The ex-spouse who's suing a family member and wants to claim an interest in the family business. We want to exclude that person. We need to have the operating agreements in effect. And that's something we frequently see. People create these entities and they leave that out. And that's also a complaint they get. Gee, I can set up this LLC myself. I can go down to the Corporation Commission or I can go to LegalZoom and it's a couple of $100. Why should I come to the law firm and spend a lot of money? And the answer is because instead of just a naked entity, it's going to be fully documented with all those ancillary support documents that actually give you the protection that you want. Now, this ownership versus control thing, that's extremely powerful. And I want to illustrate one of the ways that that plays into estate planning with a concept called discounting. If you're going to go sell a piece of real property, and see a rental home, and let's just, for nice, easy numbers, we say it's worth $300,000, and let's just say it's paid for, there's no mortgage on it. So what's the value of that rental home? It's $300,000. Well, what if we want to give that property to our children, but we don't want to use up $300,000 of their exclusions? Now I have to lay the foundation of what are these exclusions. When we transfer property from one person to another, that can be a taxable event. Even if it's from a parent to a child. A parent gives a child a property, that transfer is technically taxable. It's a gift, and gifts are taxable. And if we do it when we die, it's an estate transfer. And so there's a gift tax while we're alive and an estate tax when we're dead. And there's some exclusions to that tax. There's annual exclusions, so much that a person can give to other people every year, and they get that every year, it's reoccurring, and that's currently $15,000. So if there's a married couple, mommy and daddy, husband and wife, can each give $15,000 to a child. So combined, that's $30,000. And they get that $30,000 every year. And then there's a lifetime exclusion. Now, that lifetime exclusion is a political number. It has changed frequently. It's candidly an issue in current election politics. The outcome of the election will determine very likely what happens to that exclusion. Currently, the exclusion is high, $11 million and some change per individual. And it's indexed to inflation, so it goes up every year with inflation. And if the politicians can keep their grubby little fingers off of it and leave it alone, the law we have today is actually the best law we've ever had, in my opinion, because it hits the ultra big, super big estates, but it leaves the middle class people alone. And it's indexed to inflation, so if the politicians mess with our money and cause inflation to happen, well, the exclusion is going to adjust automatically. But again, this is very political. There are political factions that want to raise those taxes, that want to reduce those exclusions. So that's something to keep our eyes on. But if we're making a gift that's bigger than our annual exclusion, we're going to gift this $300,000 property, and we only have one child, husband and wife, $30,000 exclusion for the annual, but we now have $270,000 that's above the annual exclusion. We're going to use up part of that lifetime exclusion. So we don't want to do that. We want to keep that lifetime exclusion for later. So here's some things we can do. We put that $300,000 rental property in the family bank. And what's it worth when we put it in? $300,000. Now we're going to gift the child, mom and dad are going to gift the child an interest in the family bank with a value of $30,000. Let's say we only want to use our lifetime exclusion. Now, if the only asset in this family bank is this $300,000 rental property, and we want to gift a limited partnership interest with a value of $30,000, simple math would suggest that that's 10%. 10% of $300,000 is $30,000. So we're going to gift 10% of the limited partnership. Well, here's the deal. Remember, a couple of things about a limited partnership. The limited partner has no control. So what does that mean? It means they can't make any decisions about what happens in the partnership. It also means because they can't make any decisions about what happens in the limited partnership, that asset is not attractive to a third-party buyer. In fact, there's almost no market. If you went out and said, I want to sell my percentage of interest in my limited partnership, who's going to buy it? And the answer is almost no one, maybe even no one. So the value of that limited partnership can be discounted. And this discounting, again, has been a political issue. There have been politicians in the past that have wanted to eliminate discounting because it's based upon market values. And if you don't trust markets, if you don't trust people to make their own decisions in markets about what they buy and sell, you want to have someone else, a government agency or someone else, a politician, decide what values are, then you don't like discounting. So that's also a political issue. So instead of, when we gift a limited partnership interest with a value of $30,000, instead of it being just 10% of that limited partnership, it might be more. It might be 20% or 30% or maybe even 50%. So we get a larger value of the partnership out of the taxable estate, so to speak, by taking advantage of that discount. And with very large estates, using that discount to make gifts is extremely powerful. So we've talked about discounting, we've talked about this. Okay, so this limited partnership, I'm going to transition now into the family office.
Hey, Rick,
Yeah.
Before you transition, and maybe you're thinking this already, but one of the other nuances of risk management when we're talking about structuring LLCs or other business structures is, I know you've told the story of the golf buddy before, and the issues that can come up if you have partners that aren't covered, so to speak, in the way that you are through the planning that you've done, if you've gone through the member managed multi-member type structure planning. So can you speak to that?
Sure. So let me talk about, that's a great question, by the way. How can predatory plaintiffs penetrate the structure? How can it fail? What can go wrong here? And there are actually several things that can cause this to get messed up. And I'm going to talk about several of them, so I appreciate that question. I actually meant to talk about that, and it was on my outline, and I overlooked it. So a couple of biggies. One that is a statutory development that's evolved in the last couple of decades, and that's for child support. So you can protect your assets from a lot of creditors, but you cannot protect it from child support. You make babies and you have a court order to pay child support, they're going to penetrate whatever structure we have, and they're going to get your stuff, and you cannot avoid it. So just don't even go there. Be responsible. If you have child support payments, you got to pay it. Another one that's a common issue is commingling. We have this business structure with a business purpose, with business assets, and then people do stuff personally in it. So I'll tell you a true story. I had a client who had structure just like this and was being deposed in a debtor's exam, and the creditor had subpoenaed their bank records, and in the business partnership, there were a number of line items, and so they had the wife on the witness stand, and the attorney said, I'm going down your list of expenses here for your business limited partnership, and I see this line item here. Can you tell me what business purpose was for the undergarments you purchased at Victoria's Secret? And I was present, and the woman turned pink and said, yeah, that was a personal expense. And because she commingled, because she bought something personal through a business account, and she couldn't hardly claim, oh yeah, that was a corporate gift, we gave that to a client. No, underwear doesn't qualify for that. So because of that commingling, it gave the plaintiffs leverage, and ultimately there was a negotiated solution. So the plaintiffs had leverage in that. The third one that Michael mentioned is the golf buddy problem. By the way, one of the greatest things for our business of asset protection is when somebody's friend gets sued. The friend gets sued and they lose everything. And then their buddies all go, wow, I don't want that to happen to me. I'm going to go get some protection. Similar things happen when a family member dies and there's a probate and they go, whoa, that probate. By the way, we love probates. We want to do as many of those as we can get, but they go, that was expensive. It took a lot of time and was aggravating. I want to avoid that. So then they'll come in and do estate planning. But we had a situation some years ago where there were 5 golf buddies, all kicked in $1 million, and they put $5 million down on a large apartment complex and financed $10 million. $15 million deal, $5 million down, financed $10 million. So lots of equity, lots of cash flow, plenty of cash flow to support the debt. And then 2007, 2008 happened. The market crashed. And in the great wisdom of the politicians, they had changed the banking regulations to adopt a policy called mark-to-market valuation. It used to be that if a property had sufficient value to support the debt at the time the debt originated, that was enough. But the rationale was, in order to take advantage of rising markets, the value of the property could go up. We want to let the borrower borrow more, so we're going to have the properties revalued every year. Well, that's really a happy thing when markets go up. But what does it mean when markets go down? So 2008 happens, the crash hits, the bank requires a valuation of this large apartment complex that was worth $15 million. And the valuation comes back for $8 million. Now the value of the property is $2 million less than the loan. So it's a non-compliant loan for banking regulations. And the bank is compelled, frankly, by the regulators to call the note. So they called the note and said, okay, pony up. We need $10 million right now. 2008, who was lending $10 million? No one. Who had $10 million of cash laying around? Well, maybe there were some people, but not these 5 guys. So at the end of the day, the bank takes the property from them. They lose the property. And the bank then doesn't want to keep the property, so it dumps it. And how good was the market in 2008? It was terrible. So they sold it for, I don't remember, $2 or $3 million. And there was about a $7 million deficiency. And they sued all 5 of these guys. $7 million judgment. Got it. No big deal. Hands down. Now, 2 of the 5 guys were our clients and had this family bank structure, and their assets were structured and had been structured this way for a long, long time. So their assets were basically insulated from this liability. And in the negotiations with the bank, I was there. And we said, here's our cards. We turned all the cards face up. We showed them what planning was in place. And we said, you can't have any of our clients' assets. And the bank said, oh, we agree. Okay, you're excused. So our 2 clients left the room. The next day, both of our 2 clients called us up and said, we're going to pay the judgment. And I said, why? You have no legal obligation to pay the judgment. And here's what they said. Well, our 3 golf buddies, who, by the way, we really asked them and pestered them to do the same kind of planning, but they refused to do it. They're all 3 liable. And they came to us and said, if you don't pay your share, the bank's going to make us pay your share. You dirty, rotten scumbag. You pay your share, or we're going to hate your guts and think you're a traitor and a deadbeat and a bad guy forever. So our 2 clients, who had no legal obligation to pony up, ultimately through peer pressure and this social obligation with their golf buddies, paid up. So we can protect you from the liability technically and legally. We cannot protect you from your golf buddy. So the moral of that story is, when you're doing a business deal and you have partners, your partner's failure to plan and protect themselves can hurt you. So we encounter this a lot. People come to me and say, oh, we're going to do this deal. We want to set up this company between the 2 of us. And we'll go, okay, well, what other planning do you have? And turns out one will have really good planning and one won't have any. And our position is, if both parties don't do appropriate planning, both parties are exposed to the risk. So that's a huge issue that comes up with exactly this family bank and similar structures. So thank you for that question, Mike. That was a good question. So looking at our risk management, remember containing risk and excluding risk, keeping our dog in and keeping the neighbor's dog out. The limited partner has a way that the dog can get out, and that's through the general partner. The general partner has general liability for anything that happens in the general partnership. So we want to contain that risk. That's where this family office enters in. And I want to kind of give some introduction to the concept of family office. You've probably heard that term if you've dealt with high net worth families. It's a word that's thrown around a lot. And the family office function is an entity or a structure or some systems that administer the business of a family's holdings. And in particular, in high net worth families, they're going to own lots of properties and lots of businesses and lots of investment accounts. And they're going to have accounting issues and legal issues and investment issues and tax issues. And so it only makes sense to have a place where all of that happens. And often those services are outsourced to companies, businesses, that what they do is they provide family office services. And what they want to do is manage the money or manage the investments and do the accounting and the legal work. Well, that idea really works, which is why ultra high net worth people do it. Well, why can't everybody else do it? And the answer is, well, they can. So we are using this family office concept, and frankly, we do it for ultra high net worth people too, but often it's suitable for people that don't have hundreds of millions or tens of millions of dollars, but they have less, but what for them is a lot, and it's all they have. So who needs the family office? And there's several thresholds. If we're doing significant asset protection, the family office makes sense. If we have a large, complex estate, it makes sense. If we have lots of business entities, so a complex or a growing business structure, so the serial entrepreneur, the person who, they got 3 businesses today and they're going to have 6 next week, and in 3 years they're going to have 29. The serial entrepreneur will really benefit by this family office. And it's a place, it's an entity in which we are going to consolidate control and management and certain business activities. And in general, the family office is not going to own anything, with a couple of exceptions. One exception being that 1% general partnership interest if the family bank is a limited partnership. But if the family bank is an LLC, it won't own any part of the family bank, but it will be the designated manager. Remember, LLCs have members that are owners, and they're controlled by a manager. This family bank will be the third-party manager. And I want to talk about how this is owned, because its ownership is very significant. And on the diagram here, I think you're still seeing our screen share. You can see these little blue arrows and the green arrows coming into the top of the management company. And you'll see we've got over here the blue arrow, it's got 5.1% voting and anywhere from 0 to 90% non-voting. And the green arrow, we've got 4.9% voting and anywhere from 0 to 90% non-voting. So let's ignore the non-voting for a minute. Let's just think about the voting. What is this 5.1% voting and 4.9% voting? What does that mean? Those numbers mean something. What does it mean? It means, well, one of these owners here has control and the other one doesn't. So let's follow the arrow and let's look and see who has control. So control in this situation, the blue arrow comes over here to the blue trust, which is the family trust or the revocable trust, which is, for all practical purposes, the client, husband or wife, or the husband, or just the man or just the woman, or whatever the couple is. If whoever the client is, ultimately it's the client that owns that, and that client has control. Well, where do the green arrows go? Those green arrows flow down here, and we'll chase them down, and they come down here to this dynasty trust. Now, the trusts are another seminar. We've talked about those in other places. This irrevocable trust is a trust that's outside the taxable estate, that's unavailable to creditors. It's a very powerful tool for creating asset protection and for structuring assets outside the taxable estate so that they're not taxed when you die, but are also unavailable to creditors while you're alive. So by structuring this family office with the majority of the voting over here, the client has control. That's what they want. They want control. But they could have almost zero equity. In fact, all of the non-voting interests could be owned by that dynasty trust, the green trust on our diagram here, outside the taxable estate. That's very significant, and especially depending on how we've chosen to have this family office or the management company taxed. And typically, this is going to be taxed not as a partnership, not as a disregarded entity. We're going to choose to tax it as a corporation. And we're going to choose for it to either be taxed as a C corporation or as an S corporation. And it kind of depends on the size and the scope and scale and nature of the operations of the business activities. If this is a very large client with lots of business activity and they have lots of revenue streams from multiple sources, from different businesses and different properties, this is probably going to be taxed as a C Corp, in which case we're going to structure this right out from the beginning so that 90% of the non-voting is all owned by the third-party dynasty trust, that green trust out of the taxable estate. So how much of the family office would the client own here? They would own 5.1. So if they file bankruptcy, for example, which would be a worst case scenario for asset protection, they have to list all their assets. And what are they going to list? They own 5.1% of this company. That's it. What's it worth? Nothing. Because it doesn't in turn own any assets. So it becomes an asset in a bankruptcy or in civil litigation with little value, even though it has control. But you'll see here that we've called this hair trigger, business hair trigger. Let's say that in the course of the bankruptcy or in the civil litigation, it became necessary and appropriate for the client to no longer have control. And being compelled to do something you don't want to do by a court is one of the situations in which it's better not to have control. So we want to get rid of control. Now, one of the things we have to avoid is a fraudulent conveyance in this big yellow banner you see down here in the lower right-hand corner. This is all about fraudulent conveyances. We don't want those. So for a transaction to be fraudulent, let me tell you what that means. That means it's done without consideration. So we just gave something away for somebody. So the guy who says, oh, I'm going to file bankruptcy and I don't want my assets to be subject to that, so I'm going to give my property to my brother before I file, that's completely bogus. Just doesn't work. That transaction will be unwound by the court in a hurry because that's a fraudulent conveyance. They gave the property away for no consideration. The other way for a transfer to be fraudulent, if it's for the purpose of preventing creditors from exercising their lawful rights. So we don't want to do that either. Our purpose for whatever we do is not for that. So you'll notice in our yellow banner here, all transfers are for value, so they got paid, or they were for the purpose of expanding the business, growing the business, making more money so that we can pay all lawful obligations. So it's important that we, in fact, have that purpose and that our transactions conform to and represent such a purpose. So with our business hair trigger over here, we want our client to no longer have control. So how do we avoid or get rid of that control? And the answer is they can sell 0.2% of this management company for value, for what it's worth, and sell it to someone else. And that someone else could be a related party. It could be the Green Trust, the Dynasty Trust. It could be one of the kids. It could be a good friend. But we sell 0.2, and the effect of that is now the client no longer has control. So if the bad guy, the predatory plaintiff, tries to compel them to do something they don't want to do, they can say, I would if I could, but I no longer have the legal authority or capacity to do that, so I just can't do it. So that's that business hair trigger. And a hair trigger, if you're familiar with firearms, it's a trigger with a very small pull. You don't have to pull it very far, and the firearm discharges. Similar thing here, we can sell that 0.2% interest for a very small amount. Doesn't require a large amount of consideration. It does take some consideration, but not an enormous amount, so we can divest control quickly and easily. Now, that's through the scenario of it's taxed as a C Corp. Sometimes we want that family office to be taxed as an S Corp. And this is particularly the case where that family office has ongoing, very active business activities, and we're trying to get the tax attributes of S Corp treatment of that income, which there can be some tax advantages to that. In particular, it can help reduce the payroll tax or the self-employment tax on some of the income. And sometimes this depends on what we're doing. If we have, in fact, I'm going to show you here a different diagram. If we have a real estate professional, for example, who owns a professional practice, sometimes we'll have that professional practice taxed as the S Corp, as you can see the orange box in the middle here, so that they can get their S Corp treatment that way, and we'll have the management company taxed as a C Corp, so we get the C Corp treatment, and then we can play those off of each other, and we can take income either through the S Corp if it makes sense there, or through the C Corp if it makes sense there. So if we're going to have this management company or the family office taxed as an S Corp, we're probably going to have the Blue Trust own that 90% non-voting interest. That's just a trade-off that we get there. The C Corp or the family office also needs to have business purposes that are not just merely tax treatment. And it does in this instance. Its business purpose is to control. And because it is the general partner of the family bank or the manager of the family bank, and for all subsidiary LLCs, so we may have subsidiary LLCs like this orange one on the diagram here that own rental properties, that own other business entities, that own investment accounts. That management company or the family office is the manager of that. So that's part of its business purpose. Now, what is this management company going to own? Well, you see some things listed there. It's going to have business operations, so it can have employees that are shared. So if we're running property management through here, it can have employees that manage properties, the maintenance crews. If we're running multiple businesses, so for example, I have a client that has a series of auto shops, and they have a dozen different auto shops, and they might work at any one of a dozen different locations, but all the employees are employed at the management company. So it doesn't matter whether they're going to location 3 or location 7, their paycheck comes from the same place, and so the employees become a little more portable. We can also put business vehicles here, business equipment. It can be the payroll master, which is really cool. And because this is where we control things and have our business activity, this is where we can conduct family business enterprises and activities. So, for example, when a family has a complex business structure and there are multiple rental properties, there's multiple business operations, and the family needs to meet periodically to plan and map out what they're going to do with all those business things, the family can have that business retreat in a pleasant location. And the costs of that business retreat can be paid for by the management company. And the family goes to that pleasant location, and they need to, in fact, have a business meeting, and they need to, in fact, conduct their business there. But then when they're done with their business, they can go enjoy that pleasant location wherever they happen to be, whether it's at a lodge at Big Bear Lake in California where they go skiing when they're done, or at a beach in Kauai, Hawaii, where after the business meetings they go and enjoy the beach. And I want to kind of show on the diagram here, you'll see these blue arrows. They kind of show cash flow. And in the family bank here, things can come into this in a variety of ways. Any of the parties can make capital contributions and withdrawals. So you can put rental properties in here, you take rental properties out. And money can come out of this partnership as K1 income, as loans, and loans can be repaid. And that can also be this green dynasty trust down here, again, can make capital contributions and withdrawals, can have loans that go back and forth. And I want to illustrate how this works with an example. So, and this will kind of show how the family bank and the family office work together, and you'll see the banking function with a multi-generational plan. I'm going to expand this a little bit so you can see more things more at once. So let's say we have a complex multi-generational family structure. The parents and the children are buying rental properties together, and they have LLCs that own rental properties, and those LLCs are owned partly by the children through an irrevocable trust, partly by the family bank. And let's say the daughter here, we'll call her Missy, just to for convenience. Missy and her husband are going to go do their own deal. They found their own property and they want to buy it. And they want it to be separate from the family structure because they're branching out on their own and they're doing their own deal. Well, how can they take advantage of all this business structure here? How can they reap the benefits of that and preserve the protection that they've got? So Missy and her husband here, in fact, I'm actually going to pull this on here. Let me see if I can pull this on here, and I'll show you how we might do this. Missy and her husband here will form an LLC here, and I'm going to shrink the size of that down so it's not quite so obnoxious. They're going to form this LLC, and this LLC is going to buy a property. And this LLC is going to be owned by Missy and her husband's trust. I'm not going to put the trust on there, but they're going to have a blue trust similar to this. Well, how is this entity going to get the money to go buy its property? Now, it could go to a commercial lender and get a loan, but in this situation, the family bank has money. It's got properties, and it had people have had life insurance, and they've been growing, and there's cash up here. So Missy and her husband form this new entity, and this new entity is going to borrow money from the family bank. And what does the family bank get? The same thing that any other lender does. It's going to get a mortgage on that property that Missy and her husband are buying. And it's going to secure that mortgage with a deed of trust, which everybody that's online with us here that's a real estate professional, you're familiar with those kind of security interests. Now, Missy and her husband were able to acquire the property. They were able to qualify for the loan because Missy is Daddy Warbucks and his bride's a daughter. So they said, yes, we'll loan you the money from the family bank here. So they qualified for the mortgage, and the property generates income. They picked a good property, so it generates income. They're able to make the mortgage payments back to the family office. So the family office has a good investment in a deed of trust that pays them a reasonable interest rate. And Missy and her husband are able to build equity in that property, and eventually, as they build that equity, pay for their own retirement and their own lifestyle. Now, let's say Missy's husband faked us all out, and he was a decoy. He was a deadbeat. And Missy's husband leaves the marriage and abandons Missy. And when he leaves the marriage and abandons Missy, he also abandons his obligations to make those rent payments on that commercial property that Missy and her deadbeat, soon-to-be ex-husband bought together. So when Missy and her deadbeat ex stop making payments on the property, what is the family bank going to do with its security interest? Well, it's going to enforce its security interest. It's going to foreclose, and it's going to take the rental property away from this business entity that Missy and her husband set up, and it's going to take the property back up here. So what have we done? We scraped off the deadbeat. We got rid of him. How much of that is he going to get in his divorce? Zero, because they lost the property to foreclosure. So what can the family bank then do with that rental property once it takes it back? Well, because there's a dynasty trust involved, at the end of the day, that property can be rescued and preserved for the benefit of Missy. Now, let's look at a kind of a variation on this scenario. Let's say Missy's husband here, he's not a deadbeat. He was a decoy, and he was dishonest, and he cheated on her, but he's honest, and he continued to make his payments on this rental property down here. Well, okay, his equity is going to be preserved, and when the divorce happens, he's going to get his equity, but to do that, they had to keep making the payments. So if they keep making the payments on the property, their equity in that property is going to be preserved. They're not going to lose it. So that's kind of an example of how this can work. By the way, a lot of families, some high-profile families that are well-known, who have multi-generational wealth. This is an example of how they have built that. They didn't just give money free to generation 2 or 3 or 4, but capital was available on a low cost and even preferential basis within the family, so the generation 2, 3, and 4 could build their own wealth and leverage off of the capital of generation 1, which is why this kind of multi-generational planning is so powerful. So in summary here, the family office is where we have control but no equity, and we can manipulate the ownership so that the family office cannot be taken away from the family. The family bank is where we have equity but no control. We want control and equity to be in 2 separate piles so that we can protect them. And we want that equity and control to be protected through the trusts so they're not vulnerable to the problems that individuals have in terms of bankruptcies and marital problems and so forth. So all those things are owned by the trust. So that's kind of the summary. We have just a few minutes here. Are there questions? And we can invite questions through the comment feature. If anybody has questions or comments or wants to throw rotten vegetables at us, we can welcome that now. I haven't seen any questions pop up. Wow, okay. So, in the absence of questions or comments, Michael, we'll get a thumbs up. Thank you. Thumbs up to all of you as well. Michael, would you like to have any closing remarks?
Yeah, I just wanted to say to all those out there who have either had first exposure to this or maybe they've heard some things about the family office and the family bank and they've got a little bit more information today. As you can tell, Rick is a wealth of knowledge on these areas of business planning and integrated planning. So you can certainly feel more than comfortable if you have any clients who are in a situation where they may need this type of planning, or you feel like they may have some questions that they need answers. Certainly feel free to have them call us, and we'd be glad to answer any of the questions that they have. Or if you personally or in your business have questions that relate to this or any other area of estate planning, please feel free to give us a call. We'd be glad to answer any questions that you have, and we're not gonna bill you for it within reason, obviously, but we'd love to be able to partner with you on these types of issues.
Yeah, thank you. I want to add to that because I think everybody on our webinar here is a professional, and part of the way we have built our profession is by being a resource and a tool to help and facilitate the success of other professionals. So if we can help you, if you have questions, if you're encountering a situation where some of these kinds of structures are involved and you just need to know how they work or what kind of concerns or issues are there, we can help with that. Or if you encounter people that are concerned about asset protection or have an estate large enough that they have an estate tax, or are dealing with succession issues of how do we transfer this wealth to the next generation without messing them up or without exposing it to the in-laws or to other risks and concerns, then we can help with that. And we're going to, by the way, we have an agenda. I think we have several more of these webinars that we're going to put on. We have a multi-subject topic agenda that's going to come up. So we'll be posting more
Awesome.
That will make you aware of as we move forward.
Hey, Michael or Rick, it's Mara. I'm wondering, do you guys have any kind of flyers or marketing pieces that you could get out to us that we can share with our database?
Absolutely, we do. We have several. First of all, we give you a sample of this diagram if anybody wants that. And we have some hard copies or PDFs that we can send you, and we will send you some of those. And also go to our website, durfeelawgroup.com. We have tons of articles and videos that talk about these things, that talk about how they're structured. And if you find, as you're going through the materials that we're going to send you and the materials that you find on the website, if you find that there's a persistent question or something that doesn't make sense, odds are somebody else is having the same question. And sometimes we're so close to the forest that we can't see the trees. We don't know what the good questions are because it's familiar to us. So getting your perspective, coming in fresh from the outside with new perspective, if you say, wow, this part doesn't make sense, or I just have a question about this over here, please ask us. And not only will we answer your question, but we'll probably take that and write another article and post it so that when somebody else has the question, there will be a resource out there for the future. A lot of the articles, in fact, that you see on our website are a result of somebody asking a question. And we go, oh, great question. Let's address that in some detail. And so we can put together some materials like that. But we will email you some PDFs of some things that can help with this.
Okay, thank you.
And with that, let me see here. Do I have it's time to end. Oh, that was the wrong sound. I didn't want that one. Time to end. Here we go. It's sad to end. The joke's on us. Okay. So, and now, signing off, Michael Koberlein and Rick Durfee from the Family Bank and Family Office Training.
Thanks, everyone.
Thank you. Super good. Super good.
Thanks. I hope this was helpful. If you have feedback for us, like, hey, you bozos, that was stupid. Why didn't you shut up an hour ago? Or we wish you'd covered this or that. Please send us the feedback. We love that. We enjoy doing these. It's a lot of fun. And we hope that it's helpful. So send us your feedback. And with that, we're going to sign off.
Just a heads up too, guys. I put our contact info in the chat. So if anybody needs that or wants it, you can get that there. Also, you can find us on durfeelawgroup.com.
Awesome. Thank you all. Have a good one. Stay safe. Make money. Succeed.